I'll resume the Stream 1 hearing. It's day 2. We'd allotted 15 minutes for any procedural issues. I do have a question to ask Mr. Warburton, who's going to start first, but other than that, I don't have any, not advised of any procedural issues. Mr. Marshall? Well, in that case, we'll utilise the time, and Mr. Warburton, you join us on behalf of Ms. Smith. The question I had to ask you is the fact that you have a rather large presentation that was provided on Sunday afternoon, and the directions say 2 working days before the commencement of the hearing, so it's a bit late. So I'm inviting you to talk to me about that question first.
The presentation was provided to the council on Sunday afternoon.
Yes, that's right. The hearing started on Monday morning.
I thought it's 2 working days before the presenter was presenting, not 2 days before the commencement of the hearing.
All right. Sounds like
my apologies if I've misunderstood the panel's instructions.
Okay, Mr. Warburton. So I did mean 2 working days before the hearing commenced, so we could have good time to read it. Could you keep that in mind? I'll issue I didn't realise my minute was ambiguous, but I will sort that out.
It may well not have been. As I said, I might have misread it.
So the message is, next time, because I know that Ms. Smith has a range of submissions on a range of topics. The idea was 2 working days before the actual hearing started, before the appearance, and the reason for that, I don't want to appear unduly technical. The reason for that is so that we can read and absorb all the presentations, and then ask and take the opportunity to ask the 42A author questions that appear to us arising out of that presentation. So, so that's why it's important. But we have found 15 minutes in the timetable. So my suggestion is that you take 15 minutes to present your presentation, and then we'll have questions after that. Will that work for you?
Yes, that's fine. Thank you.
Please proceed.
As you know, I'm Brian Warburton, and I'm presenting in support of submission 168. Thank you for this opportunity. I intend to read the presentation, but I'm happy to take questions as I progress. At paragraph 13, I intend to deviate temporarily from the prepared presentation, primarily to respond to comments made at Monday's session. A response is essential, and hence I seek leniency in respect of the indicative time allocation for this presentation. I'm happy to provide a copy of these speaking notes. The council summary suggests that the submission 168 covers 124 points. All these submission points will assist the council. 7 submission points have been allocated to hearing stream 1. Those points fall into 2 groups: statutory context and delineating council's jurisdiction. Now, by way of clarification, this submission has not questioned whether the inland extent of the coastal environment has been accurately determined or not, which was the inference from Monday's hearing. The mapping issue raised in the submission and the subject of this hearing relates only to the definition of mean high water springs and therefore the extent of the CMA. The coastal environment overlay is a different entity. For example, it doesn't have a seaward limit for obvious reasons. The submission is about the seaward limit of the district, defined by mean high water springs. Paragraph 5. I note 2 panel members have been involved in the Natural Resources Plan hearings and the determination of mean high water springs at Titahi Bay, so they will be familiar with the relevant considerations. Statutory context. The submission identified erroneous references in the plan to land above the line of mean high water springs. In the definition of the coastal marine area and in the context of the district, The Act refers to the landward boundary and the seaward boundary. To ensure consistency and to avoid confusion and to assist in administration, the submission requests deletion of the word above and its replacement with the word landward. The planner has acknowledged this substitution is appropriate. Nonetheless, the planner proceeds to suggest, and I quote, the CMA below mean high water springs is the jurisdiction of regional councils as defined in the Act. The correct term and one consistent with the Act in this context is seaward, not below.
Mr. Warburton, do you think that anyone's really going to misunderstand what you mean if, like, I understood the point emphasising that the council's district is landward of the mean high water springs, but if someone says below mean high water springs, is anyone really going to misunderstand what's meant?
No, the point I'm making is it should be consistent with the RMA. The RMA uses the term seaward. It doesn't use the word below.
But the RMA uses a huge number of terms, and there's a lot of case law saying that the plan doesn't have to be slavishly repeat every term in the RMA. It just has to be clear and it has to be consistent with the Act.
Well, that may be the case law. I'm just pointing out that, in my opinion, the plan should be consistent with the RMA.
Okay, I understand the point.
In this context, the RMA doesn't use the word below. It uses the word seaward. Below is a vertical measure. It's not a horizontal measure.
Thank you. And can I observe, I don't think you need to read every word of your presentation. Can you pick the eyes out of it? Because I think you're going to take a lot more than 15 minutes to read. It's quite a detailed presentation. And certainly I thought that it's well written, and I should say, but I think that we're going to take a long time if you're going to read every word. So as I say, could you pick out?
Well, my speaking notes are briefer than the presentation I provided you. I'm not going to go through the images or the figures or the footnotes. Or
well, and in that case, I'm wasting valuable time by asking you the questions. So carry on.
Thank you. Delineating the council's jurisdiction. The submission points out that in many respects the maps included with the plan are not helpful in delineating the council's jurisdiction. In short, the seaward extent of the various zones and overlays bear no relationship to the limit in the district, the limit of the district, which is mean high water springs. Several examples are given in the submission. These mapping deficiencies fall into three categories. First one, where the maps do not identify zoning as applying to the part of the district clearly landward of high water, where the maps identify a policy overlay applying to that part of the district, but do not identify a corresponding underlying zoning. And the third category is where the maps identify the seaward extent of a zone and therefore the seaward extent of the district, which is significantly inconsistent with the limit of the CMA in the proposed natural resources plan. And my deviation to comment on aspects of the Monday session, the planner has suggested at paragraph 149 that the submission seeks identification of the mean high water springs as, in his word, it forms the boundary of various mapped features. This is not correct. The expression mapped features is not used on the submission. The reasons for seeking accurate delineation of high water are listed in 645 of the submission and repeated here. It's more basic than mapping a feature. As the panel noted on Monday, the CMA boundary is mapped and I presume agreed within the proposed natural resources plan where it crosses some watercourses, but only 5 in total. Maps 43 and 44 are attached to this presentation. As far as Titahi Bay is concerned, I've not been privy to the methodology used to determine the extent of the vehicle restrictions. Other environmental features are indeed mapped in the proposed natural resources plan, some apparently using high water as a delineating factor. For example, the maps in Schedule A and B, water bodies, of the PNRP, which include Onipoto and Pārtāmuri arms of Porirua Harbour. It is clear from the PNRP that the landward extent of those water bodies has not been adopted from cadastral boundaries. Again, I'm not aware of the methodology used to determine that landward extent of those water bodies, but on the face of it, those mapped features in the PNRP appear to provide a reasonable representation of high water, certainly one more realistic for a large part than the cadastral boundaries derived from the Linz hydro parcel. The planner agreed on Monday that the proposed district plan maps do not coincide with mapped features in the PNRP. In other words, the council has not used information already available in the RMA arena. The planner is incorrect when he stated on Monday that no submitters have sought this discrepancy to be rectified. This is exactly what is sought in paragraph 6.4.12 of the submission, namely, and I quote, the exact scope of the CMA throughout the district needs to be accurately determined and referenced in the district plan. This outcome has been sought because the location of high water is an important method for achieving the Act. Now, I won't read those out, they're in the submission. It appears this method has not been analysed in terms of section 32. Rather, council has just adopted cadastral boundaries as a proxy for high water. As outlined below, this leads to parts of the district not being subject to any zoning restrictions. As shown in figures 18 and 19 of the submission and figure 1 here, this plan zone / high water discrepancy can be as much as 300 metres. The planner concedes CMA boundary is ill-defined in the plan, as it is based on land ownership and the corresponding Linz hydro parcel. The planner then proceeds to recommend a convoluted and confusing text for the plan that purports to clarify and address uncertainty. In essence, this suggests high water could be delineated each and every time an activity close to the indicative coastline is undertaken. It's not clear what close to means in this context. Perhaps it's the same as the plus and minus margin of 300 metres referred to above. In addition, the planner recommends text and says this is if a site-specific survey determines that high water is not located in the position shown on the maps. This is a nonsense because the fundamental issue under discussion is the plan does not even show high water, let alone a high water in the wrong alignment. Using cadastral boundaries for resource management purposes is fundamentally wrong. In effect, the planner is recommending the council renounce all its responsibilities under the Act for land along and adjacent to the coastal margin. The council will be saying, for example, that it doesn't know where the building setback from the coast applies and where it doesn't. This is not conducive to the public and landowners having certainty. The planner has not stated how the impracticalities of this approach will be overcome. These include, but are not limited to, who will pay for the ad hoc high water surveys? What process will trigger the high water survey if the activity close to the coastline is permitted under the ill-defined plan, but might not be if the high water is accurately delineated? What if the owner of contiguous property wanted to object to the delineation of high water that might cross several boundaries? A plan change will be required once an ad hoc survey is complete, showing that additional land needs to be zoned. And who will pay for the required plan change? Attachment C includes additional comment from me about the planner's recommended text. The extent of zoning and overlay should be based on definitions and functions under the Act, not some arbitrary cadastral boundary that has no logic or relevance in terms of resource management principles. High water is defined in the Act. That definition makes no mention of adopting parcel boundaries by default or as the next best. If the work is done, the council will find that in many cases the Linz hydro parcel, which the planner recommends, incorporates seaward parcel boundaries adopted from land surveys undertaken in the 1800s. However, when a large part of the land within Porirua was initially surveyed, the surveys did not have the benefit of GIS or high-resolution aerial photography, nor did they know, and surely can't have anticipated, that the differentiation between high water and low water would be of such significance from a resource management perspective. The council should be using the best available information available, not the worst. In some instances, the cadastral boundaries the planner advocates are simply sketch lines from a surveyor. making the first plot in the late 1800s. More than a century later, the council now has the benefit of high-resolution GIS and aerial photography. This data should be used instead of highly inaccurate and misleading data derived from sketches some more than 100 years old. The planner suggests some additional text to address uncertainty, apparently based on similar text in Auckland's unitary plan. The planner has not pointed out that Auckland Council has abandoned cadastral boundaries and has adopted modern technology, LiDAR and aerial photography, to more accurately define the land/coastal marine area boundary in the Auckland region. Now, I've included, I won't read out paragraph 32, it's an extract from an issues and options paper prepared for Auckland Council. On this basis, Auckland Council has been able to model its high water. Cadastral boundaries have been mothballed by Auckland Council as far as the CMA is concerned. Other councils have undertaken similar work. The recently operative second generation plan for Kapiti Coast does not use cadastral boundaries as a proxy for high water or the CMA. The planner suggested on Monday that Kapiti Coast has used the Lynn's hydro parcel. This is incorrect. Refer footnote 29 on page 6, which refers to the evidence of Dr. Ian Dorr, GWRC, at the PNRP hearings. Figure 2 is a snapshot from the online KCDC planning maps applicable to the southwestern part of Paraparaumu. The image confirms KCDC acknowledges that the seaward limit of the district is about 87 metres seaward of the cadastral boundaries and therefore needs to be zoned. This is the correct approach. This is what PCC should be doing. If the planner's recommended approach was applied in Kapiti, this strip, 87 metres wide, would fall into no man's land, i.e. it would be landward of high water, but would not be within a district plan zone. It appears Greater Wellington was involved in determining the high water for KCDC, and that work was undertaken because it was more effective and efficient than undertaking ad hoc high water surveys for individual properties and activities. The planning maps for Porirua's plan are inaccurate and misleading. Examples are cited in their submission. These largely focus on how this issue relates to Whitireia Peninsula and to Titahi Bay. Figure 3 shows another example. It relates to Titahi Bay Road. Applying the planner's recommended approach here results in a 17-metre wide strip running seaward of and parallel to Titahi Bay Road being erroneously subject to the plan. But this strip is inundated with seawater twice daily and is therefore within the CMA. Accordingly, the strip cannot be subject to the provisions of the plan. The planning maps suggest otherwise, however. Attachment D to this presentation includes images of other examples, Dollyvarden, Ngātaua Domain, Golden Gate Peninsula. It's apparent other local authorities have concluded that vague and inaccurate zone district delineations using cadastral boundaries is not conducive with achieving the statutory functions and duties under the Act. If the Council does not adopt modern survey methods using GIS and aerial photography, it will be failing to identify the land it is responsible for and the land it is not, and therefore will not be fulfilling its function under Section 31 of the Act. It will be failing to have a plan that applies to the district. It will be failing to give effect to the RPS, and it will be failing to avoid inconsistencies with the regional plan. The Council should accept the relief sought in the submission. And I'll refer to paragraph 6412 of the submission points 168.43 and paragraph 49 of the Section 42A report. In addition, the Council should accept the relief in 646, 647 of the submission, which was all landward of mean high water springs should be mapped. Thank you.
Thank you, Mr. Warburton. I have an initial question that you may or may not be able to assist us with. In relation to the distinction between where there's a difference between where the PDP is mapped the edge of the district, effectively, and where the PNRP has mapped the edge of the CMA, we of course have an obligation to ensure that the plan is not, I've forgotten whether it needs to be consistent with or not inconsistent with, but it means the same thing, with a regional plan. Do you think that legal obligation applies, that we should necessarily adopt as the PNRP position as a matter of law?
I think that's what I just said in paragraph 45. If the council doesn't accurately map or adopt a mean high water springs, which is an accurate representation of the mean high water springs, that we're failing to avoid inconsistency with the regional plan.
So, so the answer is yes. Thank you. On the substantive issue, my understanding, imperfect though it is that any line that's not surveyed is going to be indicative to some greater or lesser extent. Is that your belief? Like any line on the map purporting to represent where mean high water springs are is going to be indicative if it's not surveyed.
Or even a surveyed line is inaccurate to a certain extent. There's no such thing as 100% accuracy. But I take the point. But now I could be wrong here, but as I pointed out in the presentation, Auckland Council has used high resolution aerial photography, modelling of the tidal situation, which I think has a return period of 18 years. So they and LiDAR data, and I think they've come up with an accuracy of mean high water springs plus or minus 100 mils. Now that's certainly preferential. It's preference. That is a much better outcome than relying on cadastral boundaries, which I've pointed out can be inaccurate by up to 300 metres.
And part of the issue that I perceive that we have is that we don't have a surveyed line. We don't have a line based on the same methodology that was used in Auckland. We don't have the evidence of where such a line would be. So in the cold, hard light of day, what do you expect us to do? Like, we've got to make a decision on the submissions before us and the evidence before us. So what's the go for it? What decision are you suggesting that we make in response to your submission or your Smith's submission?
To be frank, the council doesn't even have a line showing mean high water springs. It doesn't have the basics of identifying the district. There is no line. But the solution to this issue was outlined in the submission.
Yeah, I know, but that's not a solution we can implement by our decision. That's a council decision in terms of allocation of resources, sending people off.
No. The solution outlined in the submission was that the council could simply adopt Lynn's coastlines.
Oh yes, like I was going to come to that. That's your interim position in terms of most of your reasoning. It's like, in effect, A and C of the. Like, I can't see that that's within our power, and I'm inviting you to tell me if I'm wrong, why I'm wrong.
You don't think it's in your power to identify the extent of the district? Sorry?
we don't have the evidence to do that, is my point.
Well, I'm saying you do because there is a Lynn's coastline boundary,
Well,
which is certainly more accurate than using the cadastral boundaries. And as I pointed out just now, there are GIS information associated with the proposed natural resources plan, which to me, pretty much the extent of those two water bodies, the two arms to Porirua Harbour, the landward extent of those water bodies pretty much matches the Lynn's coastline.
Now, I was going to, the track I was going to take you was that we don't have the material to, as you say, accurately determine and reference. What we could do is adopt your interim position and adopt the NZ coastline polygon. The question is, you're telling us it's more accurate. Why do you say it's more accurate? On what basis?
I think there was an attachment to the presentation. I'm sorry, it was the attachment to the submission. Those various examples where there is a clear discrepancy between the zone limits in the district plan and what is clearly can be identified is the land, the interface between the land and the water.
But
the discrepancies are so clear from those images. It's hard to suggest that there is not an issue.
well, no. My point is, you've told us that the New Zealand coastline polygon is preferable. What I'm asking you is, what is the basis for that submission? Because that's the bit I don't understand.
Well, when you bring it up on a screen, you can see that there's a better representation between the Lynn's coastlines polygon and the aerial image than there certainly is with the district plan maps. For example, the image of Dolly Varden that I've attached to the presentation. So that image of Dolly Varden shows an area on the council maps which has no zoning. Now, if I do that same image using the Lynn's coastline polygon, the Lynn's coastline polygon matches the southern edge of that parking area.
Do you mean where the red line is, or the edge of the car?
Shall I share my screen?
Please do. Yeah, that would be. Let's be clear about what you're saying here.
Can you see that?
Yep.
in my cursor?
Yep.
Okay. So if I was to bring the Lynn's coastline polygon up on and overlay it onto this map is an extract from the district plan. If I was to bring the Lynn's coastline polygon up, the edge of the polygon would follow that line there.
The red line.
Yeah.
The red,
Yeah,
the red line on the seaward side.
On the seaward side, that's right. Now, that would be the case for all of these areas where there is a discrepancy. Similar with this one at Golden Gate Peninsula. If I was to bring the Lynn's polygon over and overlay it onto this map, the Lynn's coastline polygon would follow this red line here.
Okay,
this is Pawataha Nui Inlet. This is clearly land because it's permanently vegetated. But the district plan suggests it's not part of the district and it hasn't got a zone.
okay, I've got that clear, thank you. I've one other question.
Oh, sorry, could I just want to interrupt, but I found what I was trying to find before. I think it's the last attachment to the submission. So there's the last attachment is attachment. Well, so there is only one attachment to the submission. So it's attachment A. And in the submission there are several snapshots of parts of the district. The first snapshot is the district plan. So this is part of Whitireia, opposite Ngāti Tahu Domain. So that first image is a snapshot from the district plan. This is the snapshot showing the extent of the Lynn's coastline polygon. So if you compare those two images, it's quite clear to me anyway that the second one is more accurate when you look at the underlying aerial photography. Similarly here, this is the second image, again, Whitireia Park. In all cases, the Lynn's coastline polygon is a more accurate representation when you compare it to the aerial image underneath.
The last question I have for you, Mr. Warburton, is even if we accepted your interim solution and directed use of the Lynn's coastline polygon, would we still need a covering comment along the lines that the staff have suggested for any residual inaccuracy where the line on the map does not match or would not match mean high water springs if it was surveyed?
Yeah, well, I've thought about this after listening to another submitter on Monday, and he was talking about the extent of ecosites and SNAs and the accuracy of surveying those. And I think I heard correct from the panel, if I'm correct, was a line in a plan is the line, either you're in or you're out. So my initial feeling is that you don't need any ad hoc survey on a case-by-case basis. Just the same as Mr. Borfer doesn't need to get an ecologist out every time he wants to drive up his access track. Even though the extent of the SNA might have increased over the life of the plan. Or decreased, likewise decreased. It's a line in a plan, just like the mean high water springs is a line in a plan. It's in the plan for the life of the plan, regardless of any coastline processes. And until such time as the council wants to review the plan or do a plan change if it becomes too obsolete.
Okay, Mr. Warburton, I'll ask my colleagues if they have any questions.
Good morning, Mr. Warburton. Commissioner Williams speaking. I've just got one question, and that is that you've said that the mean high water springs line will be marked in the plan for the life of the plan. So, what would you say to me if I suggested that perhaps it's a sort of a temporal construct and that it effectively is outdated from the moment it's actually marked on a plan, that with climate change and sea level rise, that it will be outdated, very, very quickly? How would you react to that? That mapping in a way has actually more inaccuracies than the sort of text that has been suggested in the section 42 report.
Well, as I just said, this same argument could apply to an SNA. It's not a reason for not having it mapped. The council should know the extent of the district. Currently, there's nothing in the plan showing the extent of the district. And the council officer is suggesting that the fundamental obligation under section 31 of the Act should be achieved on a case-by-case basis as and when activities are undertaken near the indicative coastline, whatever that means.
So you still maintain the point that mapping gives you a greater degree of accuracy, or are you saying certainty, than text, than a written explanation?
Yes, 100%, because what is going to be the trigger for these ad hoc site surveys? I don't. In the presentation, I've I just closed that unnecessarily. Just bear with me for 5 minutes. Can I share my screen again?
Yes.
So in attachment C to the presentation, I've included photographs of 3 instances where councils initiated projects work has been undertaken close to or over or seaward of mean high water springs. And as far as I know, in all 3 cases, the council didn't do a site-specific survey to identify whether it was in or whether it was out.
Mr. Warburton, before you go on, we're looking at a very picturesque photo of a bay, which I suspect is your screen background. But we have in front of us a hard copy of your presentation, and we know what you're referring to. So you don't need to share that.
Oh, okay, so you're looking at my Niue holiday shot.
Yes, that's the one. We're feeling envious, but we'll get over it.
I'm sorry about that. I thought I'd share my screen. Anyway.
No problem.
Got the photos.
Any other questions from the panel?
No.
Yes, sir, just 2 from me. Good morning, Mr. Warburton. Commissioner McMahon here. 2 questions for you, Mr. Warburton. One, paragraph 13, where you outline the problem.
Yes. Well, the 3 categories.
Yes, the 3 categories, but essentially the problem, as you have identified in your attachments, where effectively there is no zoning applying to the land. I mean, if you use the Ngāti Toa domain attachment, for example, you don't need to share the screen. I've got the aerial photograph in front of me. So a land that, an unzoned strip of land in the district plan presumably means no rules applying to land use activities under section 9. Is that the point that you're wanting the panel to take from your presentation?
I think I've referred in the presentation to the permissive approach in section 9, and if there's no zoning, then
Yes.
there are no standards, no rules.
Yes. So in that Ngāti Tawa Domain example, at least, which would the area encompassed by the red boundary that you've shown, where there's no zoning, any dunes would be able to be removed or earthworks undertaken without the need recourse for at least a district consent. I guess that's what you're telling us. Is that correct?
That's right.
Yes.
And the same would apply at Seaview Road.
Yes. Yes. I understand the principle.
And yeah,
Conversely, does that mean that by default, if the area is not covered within the jurisdiction of the district plan and the Porirua City Council, does it then by default fall within the control of the regional council and the regional plan? Or is that a too simplistic position?
no, I don't think you could take that interpretation, because it is clearly above mean high water springs. It's permanently vegetated. It must be above mean high water springs. Therefore, it's outside the council's jurisdiction in terms of section 12.
Outside of which council's jurisdiction?
Regional council, sorry.
Okay. Hey, you've fallen into your own trap of using the words above and below there.
Yeah, it's quite convenient, isn't it?
Yes. But you mean it's not seaward of the line? Yes. How do we know that? Because, I mean, if we don't know whether it's seaward, how do we know it's not seaward of?
Well, isn't that the point of the submission?
Well, I guess it is, yeah. I mean, what I'm taking from the presentation is uncertainty where the jurisdiction lies, and in fact whether there is in fact jurisdiction over land use.
Yeah, I don't know. I see the officers are queued up to come next. The officers from GWRC, they may well have opinion about it, but yeah. I would say that GWRC would take the approach, if there was a question, they would take the approach that the extent of the harbour is as shown on maps in Schedules A and B of the proposed natural resources plan.
Okay.
Which, as I said before, quite closely, if not 100%, closely follows the Lynn's Coastlines polygon.
Okay. Just before I get to my second question, under the regime as you've commented on in the proposed plan or a plan as notified, is it your understanding that the expectation is that before a resource user undertakes work in and around the high watermark, that they would undertake a survey to determine where that watermark is? Is that the basis of your understanding of what the plan as notified requires?
No, that's what I pointed out in the presentation, that there's no obligation there's no trigger for somebody to undertake a site-specific ad hoc survey to determine where mean high water springs is.
Okay.
And that comes back to the three examples I
got that
included.
Okay. Can I just move really quickly then to paragraph 46, which is your relief? And the way I've read that is it's an either or. 46A is your preferred relief, and in the event that doesn't occur or as an interim measure, B and C occur. Is that an accurate presentation of what you're suggesting?
Well, the submitter has suggested that relief.
Sorry. Okay. Yes. Okay. Point taken. But is that your understanding of what the submitter has suggested? That A is the primary relief sought, and in the event that doesn't happen or that takes time, that in the interim B and C occur?
I think that's fair enough interpretation of what.
Okay. Okay. Two questions arising from that then, to the extent that you can answer them. What in terms of B and giving effect to B, have you or the submitter given any thought to what changes to the plan in terms of policies, objectives, methods, general introduction would need to occur to reference the New Zealand coastline polygon as the proxy delineation of the CMA? But presumably that method would need to be referenced in several places within the plan?
No, I hadn't really actually given that any specific thought, but perhaps it just could be a cross-referencing in the definition of mean high water springs.
Okay. Okay, and lastly, you under C, you've said for key sites, and you've given one example, Te Tahi Bay. In addition to that reference to the polygon, you actually require some high-resolution depiction of key sites, but what are those sites other than Te Tahi Bay?
Well, you're asking me to speak on behalf of the submitter now.
Well, I presume the submitters asked you to speak on their behalf.
I wouldn't be surprised if paragraph 46C was included in the submission prior to the resolution of the Te Tahi Bay Residents Association appeal on the proposed natural resources plan. Now, as I said in the presentation, I understand that appeal has been resolved. I'm not aware of the method used to
Okay.
identify the vehicle restricted area at Te Tahi Bay, but maybe that meets the requirements of.
Let me just rephrase my question briefly. For item C, does the submission provide any guidance as to what the key sites might be under 46C? I don't have the submission.
Other than specifically referring to Te Tahi Bay, no.
Okay, thank you. That's all from me. Thank you.
Mr. Warburton, Commissioner St Clair, just when you refer to the definition of mean high water springs, what's the definition you're referring to? Just to clarify that.
Oh, it's the one that's in the definition of the CMA.
So, the definition of CMA in the plan, or the definition of so that
In the RMA.
in the RMA, but doesn't that just define what the coastal marine area is? It doesn't define what mean high water springs is.
Well, fair comment. Yeah, there are technical documents which outline the process by which surveyors or anybody using GIS data can adopt or implement or use when undertaking surveys,
Yeah.
either on or near the coast or riparian areas.
Yeah. So that I'm just trying to understand, as I understand that definition, which is just for a 24-hour period, and in relation to lunar cycles and all that kind of thing, it's not exactly, it's not a fixed line at one point in time.
No, well,
Is that correct?
my understanding is it depends which method you choose. As I pointed out, Auckland Council have accurately modelled over a theoretical 18-year period the tidal fluctuations in Auckland, and have come up and developed a GIS layer which defines the interaction of that tidal polygon with the LiDAR, which defines the contours, and identified mean high water springs to an accuracy of plus or minus 100 mils.
So yeah, but I'm trying to understand how that relates to what the definition of mean high water springs is.
Because that's the method they used to determine mean high water springs, on the basis they thought that would meet their requirements for an accurate delineation of mean high water springs.
But I'm trying to understand, rather than what the connection is, I want to know, I was trying to get to what does the definition say, and it is, do they mean the same thing?
Sorry?
So if the definition of mean high water springs is one thing, and the Auckland Unitary Plans come up with a different a method or whatever of trying to determine it so that they can put line on the plan, are they the same thing? Does the line meet the definition?
You're asking me a technical question about GIS and data manipulation, so I'm not able to answer that.
Okay, thank you.
Thank you very much, Mr. Warburton, for your contribution today. Commissioner Papare has a late one.
Sorry. Kia ora, Mr. Warburton. I don't actually have any specific questions for you, but because they've all been asked and well answered, but I did want to acknowledge your submission and the very clear and well-considered way in which you've put it together. I certainly take your point about the need for the council to know the extent of its district, and I think you've made some very compelling arguments and provided some really useful illustrations and examples for us to consider as we ponder this really fundamental issue, I think, around the delineation of mean high water springs. So thank you.
As I echo that, thanks, Mr. Warburton. Thank you for your contribution on behalf of Ms. Smith. Given the ambit of Ms. Smith's submission, I expect we'll see you again on later streams.
I think she'll be attending in person on hearing stream too.
We'll look forward to meeting her on that occasion.
Thank you. Thanks for your time.
Thank you very much.
Bye.
Can we bring in the GWRC team?
Checking that you can hear us okay.
Yes, you're good to go. So,
Right.
so you have the floor, and
Thanks very much. Tēnā koutou commissioners, e te hau kāinga Ngāti Toa Rangatira, ka nui te mihi ki a koutou. Mō tō tuku kōrero ki te kaupapa nei, nō reira tēnā koutou. Just greeting Ngāti Toa as mana whenua and acknowledging their submission into this process. My name is Fleur Matthews and I'm Team Leader Policy Implementation at Greater Wellington Regional Council. I've held this position since April 2020. With me is Mr. Alistair Smale, Program Leader of Urban Water Management, who will speak to his expert evidence, and Mr. Matthew Hickman, Manager Environmental Policy, who will be available to answer questions. Thank you for the opportunity to speak to Greater Wellington Regional Council's submission. I wanted to set the scene for Council's engagement over the course of the hearing. We asked for 30 minutes today so that we're available to answer questions and discuss any issues that you might wish to. And we certainly don't intend to use all that time on our presentation. I'll provide a brief overview of our thoughts on hearing stream 1 and then hand over to Mr. Smale, who will talk to his pre-circulated evidence in relation to giving effect to the National Policy Statement for Freshwater Management 2020. There are 8 submission points and 6 further submission points from Greater Wellington Regional Council in hearing stream 1, but they include some of the most important points that we've raised. For most of the submission points in this hearing stream, the officer's report recommends that they be accepted or accepted in part, and where we agree with the officer's report, I won't go over these again. So I listened to the hearing on Monday and then again this morning, and we'll just elaborate on a couple of points in response to the matters raised. The first is in relation to our submission point 1373, that relevant recommendations from Te Arorua o Porirua Whaitua Implementation Programme and the Ngāti Toa Rangatira Statement should be incorporated into the district planning provisions. We're of the view that Porirua City Council should have completed an analysis against each of the relevant recommendations as part of its Section 32 analysis to determine whether they have been implemented. The Section 32 analysis states that the WIP and Ngāti Toa's statement were both considered as part of the district plan review, as the process was running in parallel. Paragraph 122 of the officer's report states that the PDP broadly aligns with the documents, but it doesn't provide any evidence of this. Given that an analysis hasn't been included in the PDP documentation, we consider that it will need to be completed as part of a future plan change process so that any gaps can be addressed. In relation to the PDP, we consider that our submission points on strategic objectives, natural environment 03 and 04 are relevant. And these are our submission points 1 through 7, 13 and 14, which will be considered in hearing stream 2. Our position is that we support these strategic objectives as they seek to protect and improve the environmental quality of the harbour and its catchments. However, we consider that the PDP as notified will not achieve them. Mr. Smale will discuss this in more detail during his presentation. Secondly, in relation to our submission point 13759 regarding clarifying where sites are outside Porirua City's district jurisdiction in the planning maps, we support the conclusions reached by the officer's report. And again, we've had quite a lengthy discussion about this morning, but our position is that regardless of where a line on a map is drawn, the actual place on the ground that defines whether the district plan or the regional plan applies is at Mean High Water Springs. Mean High Water Springs must be identified on a case-by-case basis when required, and this requirement applies to both the proposed district plan and the proposed natural resources plan. The Mean High Water Springs boundary is a mobile boundary that moves on a weekly, monthly or yearly basis, and fixing the line at some point in time would lock in a boundary that may become too far seaward over time due to sea level rise and coastal erosion. The PNRP gives an approximate line for Mean High Water Springs around some particular coastal features, and this line was derived from aerial surveys and LiDAR elevation data. It doesn't cover the entire coastline of Porirua. Returning to the substantive issue for Greater Wellington in hearing stream 1, we do not consider that the proposed district plan gives effect to the National Policy Statement for Freshwater Management 2020. Mr. Smale will now talk to his evidence in relation to this matter. Unless you had any questions to begin with,
I think that we'll hear from Mr. Smale and then pick up everything together, and between your team you can decide who's the best person to answer any questions we may have.
Fabulous.
Thank you, Mr. Chair. My name is Alistair Smale. I'm the program lead for urban water management at Greater Wellington. I'd just like to add that I was the program manager for the Whaitoa program, which I think you've heard of, including the Porirua Whaitoa process. I briefly want to make 2 points from my substantive evidence. Firstly, that the Porirua City Council District Plan, the PDP, does not give effect to the National Policy Statement for Freshwater 2020. The officer's report agrees with this conclusion, and also I'd like to add that the NPS 2020 requires that changes are made to district plans as soon as reasonably practicable in order to do so. Mr. Chair, I'd also like to add that it's my view that the PDP doesn't give effect to the National Policy Statement for Freshwater 2014 either. I think the requirements for district plans are the same for those versions of the NPS. I do agree.
Can you clarify, when you say 2014, do you mean the 2017 revision or the 2014 NPS?
Both of those, Mr. Chair. Yeah, sorry for that clarification. Yes, so both the versions of the 214 and 217. Yes. I do agree, however, that a future plan change will be required to do this. In terms of the water quality situation in Porirua, water quality is degraded pretty much everywhere in Porirua, and significant improvements are required to give effect to the NPS. We largely know what those improvements are and where those improvements are needed to be made. It's certainly unclear to me whether the urban development anticipated by the plan will have a negative impact on water bodies, nor how it will promote positive effects, in other words, where those water quality improvements might occur. In terms of the role of district plans in giving effect to the NPS for freshwater, where and how urban development occurs has an impact on the environmental quality of Porirua Harbour and its catchments. This is the biggest lever that the PDP has in achieving its own strategic objectives and giving effect to the NPS 2020. However, the requirements for subdivision form and design and structure planning fall short of that. I've got one further comment to make. Greater Wellington supports the inclusion of future urban zones in all district plans. That's the job of district plans. This particular proposed plan is structured in a way that requires a plan change for development to progress development in a future urban zone. So effectively, the analysis of whether a zone is viable in terms of meeting water outcomes is put off to a further plan change. Conceptually, I don't have a problem with that. However, the mere presence of a future urban zone sends a strong message to developers in the community that development will occur in that place. This may or may not be the case. In my view, the proposed plan should be very clear about that risk and what might be required to get a plan change over the line for development to occur. Urban development should only occur in a future urban zone if it can do so within any contaminant limits set in the Natural Resources Plan as required by the National Policy Statement, and if future discharges from the development can comply with the conditions on relevant discharge consents held by Wellington Water Limited or any future Three Waters entity. Any future urban zone will also need to meet the requirements of national environmental standards, particularly for wetland protection and stream reclamation provisions. Structure plans should consider these matters, as well as being based on the principles of water-sensitive urban design. The Regional Council suggests some additions to Future Urban Zone Policy 2 and Appendix 11, which are the requirements for structure planning as part of a future plan change, and some detail around those, what might go into those two areas are contained in our submission points 13766 and 13788, which I understand will be in a future hearing stream. Thank you very much. We'd be more than happy to answer any questions.
Thank you. If I could kick off this discussion, can I take you to paragraph 12, Mr. Smale, of your evidence, your statement that the NPSFM requires a significant shift in planning and the implementation of plans. Clearly that's the case at a regional level, but I struggle to see how the provisions from the NPS that you've quoted at paragraph 10 represent a significant shift at district level, and I'm wondering if you could clarify that for me.
Yes, certainly. The big shift I think that's required is that any zoning, and particularly any future urban zoning, needs to take into account and the impacts on water, and whether the presence of that development will have either a detrimental impact on freshwater or otherwise. So that's a significant shift. The other significant shift is that where we are looking for an improvement in water quality, that improvement can only come from the existing urban footprint. So in planning terms, redevelopment is actually our friend, and that's where most of the improvements will come from. So there's a significant shift there actually that needs to be built into the provisions for redevelopment within the existing urban footprint. And the balance between any increase in contaminant loads from new development has to actually come from the reductions which are found within the existing urban footprint. So that the presence of zones and the provisions within them has a major impact on whether or not freshwater outcomes and water quality outcomes will be met. I don't believe that regional plan provisions on their own will achieve that. And I think the MPS anticipates a dual approach in this regard.
Can I just go back to where you started? You saying the big shift is any zoning take account impacts on water. Like district plans have been governing earthworks, stormwater runoff for years. On the face of the plan, it's saying avoid, remedy, or mitigate adverse effects. So how is that a big shift? Like it's not pinning it to specific standards, or so I'm missing something. So tell me.
Yes, I think the missing link here is that there is in actually identifying where urban development goes. In other words, where particular zones actually occur on the ground. An analysis is actually required to see whether or not there's either an impact or within the existing urban footprint, an improvement in water quality. So the problem in the past has been where the actual location as well as the form of that urban development hasn't been taken into account.
Thank you. Next question is that you've said, I just wrote this down, regional plan provisions can't achieve it on their own. It needs a combination, and of course the NPS directs integration. But I tend to see it as a chicken and egg, and that. So the question is, a rhetorical question perhaps, shouldn't the regional council be taking the lead and the district council moving into line to make itself consistent with the regional council's position? Your position seems to be that this plan should put a stake in the ground and then wait to see what the regional council does and then move it again?
You have a very relevant point in terms of timing. Ideally, as you suggest, the regional plan would set limits and then the district plan would follow. And of course, the regional plan would set those limits based on national instruments. Unfortunately, timing is never ideal. There's we have to play in a world where that timing is not ideal. I think probably in regards to this plan, despite the fact that changes to the regional plan won't be happening until next year, which make those limits absolutely clear, we largely know what those are. They were contained in the Te Awarua o Porirua whip, and that's reasonably well known. But I think, you're right. It's absolutely a timing issue, and it is for the regional council to determine what those limits are, and the district plan will follow. So I totally agree that the substantive changes to this district plan will need to occur after that happens.
And in terms of your paragraph 22, Mr. Smale, the matters you've specified are all regional plan matters, contaminant limits set out in the natural resources plan, conditions on discharge limits, national environmental standards for fresh water. Is there any value in the district plan saying that regional plan requirements have to be met? Is that more an advice note, acknowledging that there is a parallel set of controls?
No, I don't believe so. You're quite right in saying that these are regional plan matters, but in determining a future plan change within a future urban zone, the district council should take into account whether in fact that development is indeed possible or what form it should take. And that gets around the implementation problem of a developer going to the city council, either through a private plan change or a resource consenting and having that granted, then turning to the regional council and being declined. And that's why district plans have to be not inconsistent with regional plans. They should absolutely line up.
I've had this discussion before. Of course, what we put in this district plan can't bind what the council decides should be in a future plan change. In fact, if we purport to do so, that raises administrative law issues about fettering future discretions. It's probably invalid anyway. So how do you suggest that we actually do this?
So firstly, in relation to giving effect to the national policy statement, generally, I agree. You are very limited in terms of your decisions. What I would invite you to do, though, is to make it very clear in your decision that this plan does not give effect to the NPS 2020, and even remind Porirua City that they need to, as the NPS requires, make a change as soon as reasonably practicable. In regard to future urban zones, I think it's quite acceptable to outline in the provisions what a developer or somebody else who is looking to make a private plan change, for example, has to take into account in designing their structure plan, which then would move forward into a plan change. So what I'm suggesting in future urban zones that one of the things they need to take into account in their design, and PCC would need to take into account in making a decision, are matters related to water.
Like, that comes back to the previous point. I could understand exactly the merits of that if the mechanism for moving from a fuzz to a live zone were a structure plan process. And I may be wrong, but I think that the Auckland plan may provide for that. But if you're providing for a fuzz to move to a live zone through a future plan change, is by definition, is anything we put in this plan in the nature of a non-binding advice note, because the future plan change will say whatever the council decides it should say, or if a private developer is bringing forward a future plan change, they can draft it however they want. They may fall flat on their face, but that's their call.
Indeed. And I suppose in terms of the status of Appendix 11, which is the things that someone needs to take into account in a structure plan, I mean, that probably is advisory in its nature. And as you suggest, if they don't take that advice, they may or may not fall on their face.
I had a question for Ms. Matthews arising out of her initial statement, and that's that the submission that we should adopt the recommendations from the Whaitoa process. And this goes back to the discussion I had with Mr. Smale. Is it prudent for us to adopt the Whaitoa recommendations when we don't know when whether the regional council is going to adopt those recommendations until we see what's in the relevant plan change?
Thanks. There are some of the recommendations that are specific to Porirua City Council and to development and particularly urban development that that can be captured in the plan change. And to be honest, some of these probably have been. We haven't done a full analysis against each of the recommendations, and it appears Porirua hasn't either. But I suspect that a number of them perhaps have been captured.
But my point is that the Whaitoa recommendations are recommendations for a future regional plan change. And until we know whether the regional council is going to adopt those recommendations, is it premature for the district council to adopt them?
Yeah, I think you make a good point that it would be, it could I guess put Porirua in a difficult position if they adopt some which then the regional council decides not to adopt. But I think we've signalled quite clearly that that's unlikely to be the case.
If I may, Mr. Chairman, I'll just add to that a little bit. So the recommendations within the Porirua whip, they do make recommendations for both GWRC and Porirua City Council. Some, as Fleur just alluded to, some are specific for PCC in how they do their business, how they invest, and how they approach urban development. And most of the recommendations for GWRC are in relation to the limits and target attribute setting. So that really sets the contaminant limits. And it's all really with the background of this maintain and improve. So even the 2014 as amended in 2017 had that basis as maintain as a minimum. So any sort of urban development needs really to have that as a basis, as a starting point.
Hand over to my colleagues. Commissioner McMahon, perhaps.
Yes. Good morning, Greater Wellington team. Commissioner McMahon here. Like the chair, I was going to ask some questions of Ms Matthews regarding the three matters that you outlined in your introduction. Ms Matthews, the role of the Porirua whip, the jurisdiction of the district, and the MPS-FM. I'm not going to ask any further questions on the FM because I think Mr Smale's evidence and the questions from the chair have probably exhausted that largely. And moving to the Porirua whip, though, I guess the first question I've got, and I'll be the first to acknowledge that in a perfect world you'd have these higher order documents and the regional documents and then the district documents all lined up and each giving effect to each other in a sequential manner. But I'm long in the tooth to understand that doesn't happen, and I'm yet to see it happen. But my first question is, when was the Porirua implementation plan finalised and adopted by the Regional Council?
2019.
Yes. So immediately that indicates that it was only available after the district plan was well on the way to being notified. So, I mean, from a purely time frame point of view, there was some difficulty in actually adopting and implementing some of those provisions if the district council was of a mind to. Would you acknowledge that?
Yeah, certainly that's when the council adopted Porirua Whip. Porirua City was part of that process.
Sure.
They sat at the table, were well aware of the recommendations, probably for several years prior to that.
Yes, but Mr. Swales, until they were finalised and adopted by the regional council, it would have been premature to take action on those, even though they were a member of the whip configuration.
But that's a relevant point.
Yes.
I would agree.
Okay.
And I'd also agree that timing is never useful in these regards, and
yes.
that's why things are not perfect.
And Mr. Hickman or Mr. Mail, you might have touched on this, but what's the regional council's intention for codifying the Porirua Whip into the regional plan? What's the time frame, and what work has been undertaken to achieve that time frame to date?
Yeah, certainly. You'll be aware that there's a statutory requirement to make those plan changes by 2024. We're intending to do a number of plan changes prior to that. The Porirua, the plan change involving Porirua will be in 2022, in the second half of 22, probably August 2022.
Yes, and so that would implement those recommendations that relate to the Greater Wellington Regional Council, and in particular will be around the setting of standards, presumably, for contamination. Yes, okay. And that WIP process is one that was started some years ago and progressed through the regional plan hearings, and was still going, I guess, by the time that regional plan decisions were made.
Indeed. Yeah.
Yes, okay, thank you. Okay, just before I move on to the second issue of jurisdiction in the district, Ms Matthews, I wrote down a comment that you'd made that the Greater Wellington Regional Council supports the strategic objectives and strategic direction objectives in the plan, but is not, I think that's what you were talking about when you talked about strategic objectives, but it wasn't clear whether the PDP, as notified, would achieve those objectives. And I may have paraphrased that wrongly or written it down wrongly, but I think that was the essence of what you said. Can you elaborate on that? Firstly, referring to what objectives you're referring to, and why you think those objectives may not be given effect to by the PDP.
Sure. So it was in relation to strategic objectives NE03 and NE04, and those are the ones around.
That's the natural environment.
That's right. Seeking, but particularly to protect and improve the water quality of the harbour and its catchments.
Yes.
So, yeah, as I said, that we do support having those strategic objectives in the plan, but our submission, and I guess this will be considered in greater detail in hearing stream 2, but our submission is that we don't think that the PDP will actually achieve those objectives. Okay. And that's basically because of the points that Mr. Smale raised around them not having kind of enough in some of the lower order provisions.
Yes. So that's on the face of it, that's a serious Section 32 failure. On the face of it, and are you saying that today is not the day to discuss those? That subsequent hearing streams, you'll put the meat on the bones and indicate what changes are necessary to the lower order provisions within the PDP to achieve the strategic objectives. Is that what you're saying?
That would be our intention.
Yes. Okay. Well, that's good. Moving on to the jurisdiction matter, and I guess that's been highlighted by the preceding submitter, Mr. Warburton, Mr. Warburton representing Ms. Smith. And you may well have heard the questions that the panel put to Mr. Warburton, and particularly the question that I put to him regarding, well, if it's not within the district, is it then within the regional council? Particularly those areas of unzoned strips of land around Ngāti Toa Domain and the other 3 or 4 examples that Mr. Warburton gave. Ms. Matthews, Mr. Hickman, do you have any response from a jurisdictional point of view there?
Yeah,
Because just before you do, I mean, I think the panel recognises the point that Commissioner Williams made with the submitter that, you know, the line is dynamic, but the absence of a line, using Mr. Warburton's words, is the concern. So he drew the parallel with SNA and I think with flooding maps that we heard from Mr. Bulter the other day, that, you know, even if the line's wrong, it's important to have a line. And the absence of the line's creating a jurisdictional issue in his view. I'd be interested in your comments on that.
We support what the officer's report recommends in this regard. So that's in terms of putting a note that that the adjacent zoning, you know, where the Mean High Water Springs line turns out to be seaward of the line on the map, then the adjacent zoning applies to that area. It's not that it's not unzoned. It actually does have the adjacent zoning, and we think that that's a pragmatic way of dealing with that issue.
Okay. Do you have, I mean, I'm not sure whether you're a further submitted to Ms. Smith or not, but I'll ask the question anyway. In terms of the relief that Mr. Warburton outlined on behalf of Ms. Smith at paragraph 46 about the two different options about the polygon and that sort of thing, have you got any comment on that at all?
What I would say is that I guess with any line, you know, Mr. Warburton said that that the line was more accurate, and while that might be the case in the examples that he gave, without a proper analysis, it may be less accurate in some other areas. We haven't turned our mind to those particular recommendations, but if you would like, we're happy to report back.
Well, there could be a scope issue, and I guess I'm just asking for your feeling of the. But if you are a further submitter, no.
Don't go there.
Don't go there. Yep. Okay. and that's why I said I was uncertain of scope. Yeah. You can see though that these are fundamental issues weighing on the panel, and I mean you predetermined that, Ms. Matthews, by saying, you know, the three key issues are, you know, the Porirua whip, the jurisdiction of the district, and the extent to which, if at all, the plan gives effect to the FM. MPS. So, you know, these are themes that are run through a number of hearings, and it's just, I guess it's that they're captured in this first hearing stream at a very high level, when I guess the devil will be in the detail. So we'll be very interested in seeing detailed recommendations coming through, because even on the MPS FM issue, Mr. Smale, and I said I wouldn't get into that at the start, but I'm still not certain what changes, if any, GWRC are requiring over and above those that are recommended by the officer, because the general comment is saying that you accept most of the positions of GWRC have been accepted or accepted in part by the council or the officers, but whether they've been accepted in part, I'm not clear. Where you're going and what further changes, if any, are required. So while some of those matters might be picked up in subsequent hearing streams, for this hearing stream, are there any further additions that haven't been included in your evidence, Mr. Smale, that you're asking the panel to consider?
I know the only ones that are included in my panel in terms of your decision making is changes to FUZ P2 and Appendix 11. And we will come back to that in the further work stream.
Okay. Can you recall what hearing stream that will be? No.
It'll be around urban development.
It'll be
Next year.
Okay, that's good.
Could I just ask a related question to that? Ms. Matthews, I understood you to say that the council needed to put the limits or the recommendations of the Porirua Whaitua implementation program into the plan. So can you tell, I'm looking for which submission number point is that and what's the relief sought into that? Could you help me in relation
So-
to that, please?
Sure, it's submission point 1373.
137.3.
Yeah.
Right. And then, can I let the other commissioners ask you some questions, and I'm just going to go look at that. Thank you.
Sure.
Commissioner Kumara?
Tēnā koutou. Thank you all very much this morning for making yourselves available to answer questions. All of my questions pretty much have been traversed, so I really only have one further question for you, and I think it was in relation to an issue raised by Ms Matthews in terms of the Section 42A report. Your concern there about the statement made that the PDP aligns with the NPS, the FM, as far as practicable, and you were concerned about the lack of evidence to support that. We've had quite a discussion around the sorts of changes that you will be seeking in subsequent hearing streams. But was there anything that you could point to now in terms of evidence that that you consider should be provided in the PDP in the context of that statement? Or evidence, of the PDP aligning with the NPS FM.
So the statement I made was just around the recommendations of the Te Aurora Porirua Priori implementation program and how
Okay.
yeah, and how there was within the Section 32 there wasn't actually evidence that against whether or not
Yep.
the recommendations had been incorporated.
I see. Thank you. Thanks for the clarification. No further questions from me.
Commissioner Williams? Ready to roll?
Thank you. I found that submission in terms of the summary of the decision required, and it says incorporate the relevant recommendations. So, sorry, which ones are they? What wording do you want us to put in the plan?
Yeah,
It's not specified in submissions or in evidence.
Yeah, I realise that we have put you in an awkward position where we haven't actually identified which of the recommendations are relevant. And I kind of was trying to address that in the initial statement, really that there hasn't been an analysis against the recommendations. And so this would need to be completed at a future plan change process. But really, I guess it comes back to our points around strategic objectives in the natural environment, the 03 and 04 that I talked to before. And I think that will be the primary way that point will be able to give effect to in this process.
So when we come to those hearings, the specification as to what you actually are seeking are set out there? Is that correct?
Yes.
Okay, thank you.
Sorry, just one further from me, Ms Matthews. Can the panel take it from that perspective, and I guess the absence of any submissions relating to any 03 and any 04, that Greater Wellington's position is that they support how those strategic objectives are framed in the notified plan?
Yes.
Yes.
Yeah.
And it's more how the objectives and policies and methods sitting below those are determined and give effect to. Okay. And that will become clearer, obviously, in subsequent hearing streams. Okay, thank you.
Thank you very much to the Greater Wellington team. Appreciate your input, and we'll look forward to seeing you in future streams. Wait for it.
For your time.
Thank you very much.
Sorry, team. I did one final question. The second report that we're considering as part of this hearing stream is definitions, and the definitions that appear more than in multiple times as opposed to in one instance. I'm taking it that because you haven't mentioned definitions at all, that you're happy with the definitions as notified?
Yeah, I think there was only one definition which we were further submitted to, and the council officer has gone in the same direction that we were, and I can't quite remember if we were opposed or supportive, but
Okay,
so we have no comments on those.
good to know. Thank you.
Well, now it's really farewell. We'll look forward to seeing
Thanks
you
very much
on
for your
another
time.
occasion.
Absolutely.
We'll adjourn and have a cuppa, and then actually ask Mr. Rackman some questions. So we'll be back at 10 to 11. We'll resume the hearing. Gentlemen, to hear the much delayed presentation from Mr. Ackland. But before then, Mr. McDonnell, we've been puzzling over mapping issues. I think the resolution we've come to arising out of Mr. Warburton's evidence is the panel is going to ponder the point and give you some questions that we'd like you to answer in the council's reply. And we'll do that within the next day or so. Rackland, welcome to the hearing, finally.
A pleasure, Di.
Yes.
Thank you, Chair, and thank you, panel. With the Chair's permission, I've got a table that Commissioner McMahon asked for, which shows the activity statuses in the commercial zones for retail, supermarket, and large format retail. So I'll just hand that out.
That would be good, thank you.
Now, on Monday, you would have received, I think, copies of my talking notes as well as my supplementary. So I'm happy to go through those if you wish, or if they're taken as read, I'm happy to go straight to questions. I'll take some guidance.
I think we'll go straight to questions. Mr. Porirua has another commitment that we're working around. So we'll do this as speedily as we can. Same process as for Mr. McDonnell. My first question is about supermarkets. Anything? So that's section 3.5. Any questions before section 3.5?
Yes, sir. I've got a question in 1.1, section 1.1.
Well, that's a good start.
Mr. Rackland, it's just a generic question about the scope of this report, and I'm focusing on your paragraph 10. And this report, you say, discusses deletion and changes, sort and definitions that appear across more than one hearing stream. So I guess what I'm asking is where a definition only relates to a particular hearing stream, and I'm not sure what an example of that might be, but there'll be comment on that definition at the time in the appropriate section 42 report, presumably.
Yeah, so we tried to pick up those which, as you say, do appear across more than one, or there's a large number that were only submitted in support. So we tried to deal with those. So leaving the ones for later hearings to the ones that are in contention that need to be assessed within the context of the framework for that topic.
Sure. So there's two things arising from my perspective there. Firstly, where there's a theme coming from panel questions in relation to those definitions that appear across more than one hearing stream, can we rely on you to brief those 42A authors that this is the tenor of the panel's questions and their concerns, because we may not land the particular issue here, or if we do land it, we may land it in seek to land it in different ways depending on the context in which the definition is considered. That's the first thing, just a heads up. Can we rely on you to do that? And secondly, is it possible that even if we did land a definition here, that when we got to a particular hearing stream and we saw the particular context in which the definition appeared, whether it's a policy or a method or a standard, we might wish to revisit that definition or provide some exclusions to that definition as they apply to the particular rule or provision in place? Is that a potential invalid outcome also?
Yeah, I can see the point you're making, that it might be that if a change is made to the framework, that you might then have consequential changes to definitions to
Yes.
either include something or exclude something. So that is, I suppose, something that is a possibility and may well arise, and I think it still can be addressed at that point as well.
Yes, I guess that's good to hear those answers, so thank you for that. I just wanted to put that on the table, that those two different scenarios could arise during subsequent hearing streams. Thank you, and that was just context to the questions that will follow from the rest of the panel.
So, anything before supermarkets on section 3.5?
What section?
3.5, page 12. All right, seems to be silence. Obviously, we talked to the was it Ms. Santos for foodstuffs about this issue. The question I ask Ms. Santos is whether there should be a GFA limit in the definition on a supermarket, and I've since thought of another rationale possibly for that. Where do you draw the line between a large dairy and a small supermarket?
The way the plan is set up in that respect is it relies on using mainly retail activity and large format retail activities as the definitions. So any retail activity under the 450 will satisfy that definition, regardless whether it's a supermarket style format or a large dairy, which could equally have characteristics of a supermarket. Where that goes over 450, then it becomes a large format retail. The only time when we separate that out is the example I've used in my report, is the local centre zone, and that's done intentionally because it's not a scale issue there. The supermarket of any scale is deemed to be appropriate within that for that centre. So that's how the plan works. So it's relying on the two main definitions, with supermarkets coming in on the one where the policy specifically wants to lead that way.
And so, just for my benefit, since I'm not across these these definitions yet, so where is there are 450? Is that in the definition of large format?
That is, yes.
11 of 24, the definitions.
Yes.
It's on there.
And would that suggest that if we were to find merit in Ms. Santos's request to separate supermarkets out from, we would have to translate over that 450 square metres to provide the distinction that I have in mind, to distinguish, as say, large dairies from what you might call a superette, could be defined as a supermarket. Because at the moment, the nesting table, if supermarket is a subset of large format retail, it will necessarily import that same.
No, I would, if the panel minded, say, when we get to deciding what mix of uses are appropriate in the different commercial zones, that it wants to make specific provision for supermarkets, but it's a scale thing. I think you can rely on the definition, but put in a specific rule within the zone provisions around the scale of it and what's appropriate to that particular zone. So instead of having in that table I provided where you've only got one activity status for a supermarket that's listed, you would have that listed in all the zones as a way of distinguishing between other types of big box retail and a supermarket. So I think you can rely on the definitions. It would just be the rules framework that would be altered.
So the rule could actually do the heavy lifting, drawing on the definition, but if there's a rule differentiation between size, that the rule could specify that. So supermarkets less than X are a permitted activity in the local centre zone, and greater than that are the restricted discretionary. Is that a possibility?
Yeah, there'll be ways of carving it up, but if the issue is you want to provide for a supermarket and scale of that supermarket is an issue, then they will need to be distinguished from the definition of retail activity, because the definition of retail activity is broad.
Yes, but the definition of retail activity doesn't rely on a floor area, does it?
No, and that's...
But the only definition it does is large format retail by default. Anything that's retail over 450 is large format.
Yeah.
It is, unless you specifically provide for it as an activity, like we've done in the local centre zone does for supermarkets, where it's listed as a separate activity within its own right.
Yes. And that goes to my earlier question on day one about what's the function of the nesting tables and the relationship between specific activities under the generic headings.
Yeah, the nesting tables they're not determinative of the activity status or the activity itself. They're more of a guide. Now, they can be used to help simplify plan provisions. So for example, in the transport chapter, there's a table that sets out the high traffic generation thresholds. That's been simplified by relying on the term, for example, entertainment hospitality activity. So you don't have to list all the individual activities that fall within that separately. You can rely on that. So that's where it can be used, but it also can be used as a guide. So something like there's a generic heading, visitor accommodation, in the nesting table. That then lists the types of activities that could fall within that. So, but then they're not defined themselves. Things like a motel is not defined, or a hostel. But the example is given in the nesting table. So it's a guide of what type of activities are likely to be within that. Yes. So the nesting tables are serving a couple of purposes. They're a guide of the general linkages.
Yes.
They're a guide to the type of activities, but they're not determinative when you go down to the rules framework.
All right. Well, let's take the supermarket example that the chair's given. We know that supermarket by definition is retail, but we also know that where it exceeds 450, it's large format. So in the local centre zone, and using your table that you've just handed up, a retail activity is permitted in the local centre zone, but are you saying that supermarkets are specifically listed as a restricted discretionary activity? And where they exceed, but that presumably that's so long as they don't exceed 450 square metres, is it?
No, because they're listed in their own right and there's no threshold within the rules, then they can be of any scale.
So that argument that you've just outlined then would trump, presumably large format retail is listed as a fully discretionary activity in the local centre zone.
So through that mechanism, supermarkets of any scale is restricted discretionary. A large format retail, that's not a supermarket because it's listed separately as an activity in its own right, would be discretionary.
Fully discretionary, but by definition, by definition, a supermarket over 450 is a large format retail activity, isn't it? And I understand the intention. The intention is to make supermarkets in the local centre zone restricted discretionary by a specific listing. I'm just worried that the implication of having large format retail definition applying to every retail activity that's over 450 might be interpreted to trump that specific listing as a restricted discretionary. Is that something you've talked to the consenting staff
It's-
about?
It's more, yeah, so the plan has been obviously engaged with the consents team about what the types of things they're looking for. And that's why we've gone down the mechanism of using where we need to distinguish specific definitions
Yes.
with the intent that that would be the way of separating them out. Now, there are submissions that will be heard in hearing stream 7 on a range of topics about what type of activities should be in the local centre, scales, etc.
Yeah.
So that rules framework is going to be discussed at that point, but certainly the intent is to separate them out and distinguish supermarkets from big box retail within that zone.
I can understand the intent. I'm just wondering whether the nesting table, which lists under large format retailers, integrated retail activity in supermarkets, and then reinforces that in the definition of what large format retail is, might muddy the delivery of that intent. And you may be right. Maybe the mere listing of a supermarket as a restricted discretionary, as the specific provision, might be all that's required. But I guess I'm seeking, in light of the submission from foodstuffs, etc., that we have some more clarity around that.
The question I had occurred to me listening to your explanation, Mr. Ackland, is that looking at the page you've given us, where supermarket is listed as not applicable, that will automatically then mean that any supermarket greater than 450 m squared will have the status of a large format retail activity. Is that the intention?
That's the intention.
Okay. And that's why I've asked the question, that is there an implied position that while supermarkets are listed as a restricted discretionary in the local centre zone, that's implied that so long as it doesn't exceed 450, because the large format retail listing as a discretionary activity in the same zone might support that argument.
I can certainly see where you come from, Commissioner, on that. I'm still satisfied that by having a specific definition alongside when that particular zone will work, but I can certainly see that there could be, people may infer that that the rule restricted discretionary, but that's only for up to 450. That's not the intent, and I think it does work, but I do appreciate that the comments you're making, that maybe that needs a testing, if you like, when we get to the zone provisions.
One final question then. Does it work in the opposite direction, that if the relief the foodstuffs seek, namely that it was taken out of large format retail, would mean that supermarkets less than 450 m squared, which is not that great, not that large, would move, for instance, have the status of a retail activity that is not large format retail.
So I didn't quite catch. So if
so less than 450 m squared.
Yep.
Ergo retail. If it's not within the, no, I think I've answered my own question just as I'm enunciating. So forget that one. Let's move on.
I got this related question just about supermarkets and large format retail, just in terms of that definition of large format retail, and it's 450. Does that, if you've got a lot size that's 1,000 square metres, you've got one 500 and then a series of 100 square metres units on it. Is only one of them large format retail and the rest are just retail? Or is it because the whole lot adds up to, 900 square metres on a 1,000 square metre site, that regardless of how big the individual ones are, that they're large format or not?
So that's going to the definition of large format retail
Yeah.
and how it's worded. Okay.
So, my question, which is it? Since
So it will be, I'm just pulling it up now.
thank you.
So so in terms of the example you've used it's with a site with a number of buildings on there.
Yes.
So it's either the individual tenancy
Yeah.
on that site or the individual store on that site.
Right. So you could have a shopping mall that's got 20 stores on it that are all under 450 square metres in area, and it's not large format retail.
There is also integrated retail activity, which is in this plan, which is for those situations of multiple tenancies. So I'm assuming the example is that you've got multiple tenancies.
Yeah, is that defined, that term? Or is
It is, yes.
Okay, right, cool. And then my other question was, when we spoke to Ms Santos, she wanted to include pharmacies and service stations within the definition of supermarket.
Not sure she said she wanted to include service stations. I think she said that they would be, come within
the definition of yes,
within the operation of a service
operation of a supermarket.
supermarket.
Yes, okay. So do you have any comment on that?
I do. I would disagree with that. The definition talks about, and depending when we're talking about 80%, 20%, 90%, 10%, which is what the submissions are about, the ratio between foodstuffs and non-grocery items, I wouldn't consider a service station a grocery item. So for me, it doesn't come within the definition of supermarket, which is that blend between foodstuffs and household goods.
Isn't there a definition of service station though? Wouldn't
There-
it fall
there
within
is.
that?
There is a definition of service station as well.
So if there's rather than would it fall within the definition of service station, or would it, as I understood you to say, you think it's a grocery item?
No, I don't
Oh.
think it is.
Oh, you
Sorry,
don't?
no.
Okay.
It's not. That's what I'm saying. It's not it doesn't, for me, filling station does not come within the definition of supermarket.
Right.
And as I said, there is a separate
So that-
definition for service station.
So it would fall under that rather than any other, percentage of non-grocery items or whatever?
I don't see it as a way of being able to get a service station through the definition of a supermarket on site.
Yep.
It's quite clear in the definition of supermarket that it's non-food grocery items, and petrol is not a non-food grocery item.
Just picking up on the Commissioner's question, the suggested amendment, should it be and pharmacy or and pharmaceuticals? If it's a pharmacy, it's a separate store.
So, how would they?
Yeah, I take that point. I think it's what you've just described there is actually more accurate, that it's pharmaceuticals rather than necessarily a pharmacy.
Because a pharmacy is not a non-grocery item.
Exactly, yes. That to me, it's encompassed within that. It helps to make that clear, but you're right that the pharmacy, think of as a noun, as a place.
Does that capture the dispensing aspect of, because there's a difference between selling pharmaceuticals and actually dispensing that, a pharmacy.
My own view is it would, because they're still pharmaceuticals.
If they're still selling them. I think, unless you've...
I think it would, but it's like a lot of these things, it may be that there's some little bit of wordsmith to clear that and make
on the
that
basis
clear.
that we're short of time, can we just leave that thought with you and ask you to think about the nuance that the Commissioner's raised, whether there does need to be a bit of bit of rewording. Having last been in a Countdown pharmacy, it operated as an entirely distinct store within the complex.
And then they sell, they have pharmaceutical type stuff which is for sale on the shelves in the supermarket, and people that go to such stores don't necessarily buy products that might be dispensed free of charge.
Yeah. So as could we just ask you to think about how that's expressed? My next question is the discussion of power poles. That they're caught by the word building. Does a building have a roof? Is that the answer? A simpler answer to their concern?
I would say a building has a roof, and then a structure is probably what you'd capture as a roofless building or something like that. So those two terms often go hand in hand to cover that range of thing. But I would...
Is the reality is that all buildings are structures, but not all structures are buildings?
In my experience, that's how it normally operates, yes.
Next question I had was about the recommendation to include Punareo in the definition of childcare services, consistently with the national planning standards. If you include it, does that in turn need to be defined? Because I seem to recall planning standards say that if you use te reo terms, they have to be defined.
We haven't then defined it.
Yeah,
I've got a footnote about what it is, but no, that's not defined. So,
well, as I say, can you think about that? And in the same way, and even if it's not a strict requirement of the planning standards, would it be a good idea to insert a definition as a consequential amendment? The discussion of the difference between construction activity and building is the distinction. Could we put the distinction more simply? That building, as defined, is a noun. It's not a verb.
yes, the construction activity is the verb. It's the action of doing it. The building, the structure is the noun. It's a thing.
And maybe we could make that clearer, perhaps, saying, add to the definition of building, it is not the activity of constructing a building.
So was that to the definition of building?
Yeah.
That's a... I believe that's
that might be a planning standards definition.
I believe it's a planning standard.
Oh, well,
Right.
forget that idea.
Put it in brackets.
Yeah. Sorry, you've returned to the supermarkets. I had another question. You accepted the countdown submission that the trigger should be 90% rather than 80%. Well, you should be 80 rather than 90 as notified. Aside from the fact that the submitter asked for it, what's the basis for you accepting that? What is the evidence of typical percentage splits?
I couldn't give you that, but I took my guidance from looking at other plans, and so obviously the Auckland Unitary Plan has that 90%, 10% split, and off the top of my head, if I recall, the proposed New Plymouth Plan had that as well. So I was
So 90 or 80?
80-20 instead of the 90-10. So it's one of these things where it's trying to get that alignment with what's happening elsewhere. It's not necessarily based on evidence or empirical measures of the activity.
Related to that is, what about, what have Kapiti done since they've done their plan recently? And I'm aware that Wellington City are currently doing their plan, Hutt City are doing theirs as well. Is there any consistency between how the councils regionally are approaching that?
In terms of have we spoken to each other?
Yeah, have you spoken to each other? Have you kind of,
No, I've not had a conversation with them about whether it should be 90-10 or 80-20.
Is the bottom line that if it's 80%, it's still dominantly grocery food items?
Yeah, it's about how you slice it up, and 80% is still the predominant is foodstuffs for sale.
Paragraph 1.166, Mr. Racklin. Do we need to worry about the scope to put the correct act in? Wouldn't the Interpretation Act do that anyway? So that's a minor change.
Is that paragraph 166?
Correct.
So tertiary. Where I've relied on.
Yes, but do we even need to worry about whether there's a submission for that or similar situations? Because the Interpretation Act says where an act is referred to, it automatically incorporates acts in substitution, therefore.
No, that was based on that the previous definitions have used reference to Education Act, and whilst Kainoa wanted that deleted, still felt that was to make the definition work in the way it had before, was to replace it with the new provisions.
I got you.
and then related to that, there's this piece in the National Planning Standards about definitions, saying that where the definitions are incorporated from legislation, the definition applied is the version included in the legislation on the date of gazettal of this standard. So does that mean that rather than whatever the latest piece of legislation that we're looking at, that in the plan it's supposed to be whatever was dated on the gazettal of the planning standard November 2019, hardly precise, but is that how that's supposed to work?
So I just need to, can you
So
confirm me?
on page 53 of the National Planning Standards, section 14.
While you're thinking about it, that would seem to be a singularly odd end result. If that were,
Well, yeah, but it does,
yeah, I'm not saying it's
I'm hoping
wrong.
I'm reading it incorrectly, but yeah. Number 4.
For
Mandatory direction.
On the date of the gazettal of this standard. Some day in November 2019.
Wow.
certainly seems to say that face value, which
Odd,
but it
which
does
is
lead
not
to
Yeah.
odd sequences that. But I suppose partly when I'm looking at that, where definition list incorporates a definition from legislation.
So if you're referring to I assume I don't know, coastal marine area, you're referring to, from the RMA, it was the RMA at that date, regardless of whether it changes or not.
So after the NBEA is enacted, we're still going to look at the RMA definition of that term. That would seem...
It just seemed, I don't know the answer.
I have to say, it does seem at face value, but I'm not sure that what the intent was with that. It's quite time bound.
I'll leave the intent and those sorts of things to the chair to talk about. But possibly worth asking somebody.
I think we will. Yes.
The ministry or something like that. It's not exactly clear.
I think our request is, can you investigate further and give your best answer you can in reply to that particular curveball, which, as you say, on the face of it, does mean what the Commissioner suggests, but seems to defy belief.
Yep.
From my initial view, but you get that. In terms of your reply, can I point out to you there's a typo in your redlined redefinition of tertiary education services? We know what you mean, but it might be a good idea for you to pick it up. And the last question I have for you relates to allotment. I was a bit puzzled by what you were saying, so I went back and compared these different versions of this definition. And it seems that subsection 3 should have been in the original definition but wasn't, because the section 218 as amended had that subsection. But the question for you is, while it's clearly correction of an error, is it a material error so as to fall outside clause 16?
The view that I take is no. It's a procedural matter of getting just correct definition from the RMA, because the definition does already exist in the RMA. It's just making sure that the version we have aligns with the version that's in the proposed plan. It's also, I believe it's another one of the National Planning Standards definitions. So my view is that it can be dealt with under clause 16.
That was all I had. Any other questions, Commissioners? Commissioner McMahon?
Thank you. So, Mr. Racklin, I just want to come back to the issue of nesting tables again, sorry. And I'm just wondering, I mean, you said earlier two things, that they're not determinative and that they're a guide. Could that be made clearer in the plan? Could it be made clearer, and should it be made clearer?
I would agree, yes. Looking at it again the other day, there could be more of guidance about its use.
Yes, because you say in a couple of occasions, I think paragraph 128, that where there's an attempt to control a specific activity, you use that specific activity in the rules, and the supermarket one is a good example of that.
So 128.
I think paragraph 128, I think I wrote down.
Yeah, so I
Yes.
off the top of my head, I think someone worded perhaps along the lines, I think the proposed New Plymouth plan has about how to use a nesting table, and its
Yes.
purpose would make this plan more user-friendly.
Yes. Because if it was to have a more determinative function, it may require some changes to it. For example, just using, I've just been making some notes as you were talking and using your additional table. If we're looking at supermarkets and you go up the chain, all supermarkets come under the set of commercial activities, presumably. And then within that set, there are retail activities. And then there are different types of retail offerings, whether they're large format supermarkets or the term that you just mentioned earlier, an integrated retail activity. So when I see that sort of chain operating in the first and second pages of the nesting table, I'm looking for all of those terms to be represented, and I think they are. We've got supermarkets, we've got integrated retail activities in supermarkets, which is shown as subsets of large format. We've got trade suppliers and service stations listed, and I guess all of those terms in bold are defined in their own right, aren't they?
They are, yes.
Yes. Okay.
Yes, well, that could be something that could usefully be stated in the intro to the
Yes.
section.
That's what I was thinking about, how it could be made clearer
Yes.
to say that those in bold or highlighted are defined, the others aren't necessarily defined, and they're more for guidance purposes.
Okay. That might be useful. When does a trade supply outlet ever become a large format retail?
So again, it will go back to the specificity of the definition. So a trade supplier, because there's a definition.
Yes. It doesn't have a floor space.
No, but we'll need to rely on that definition in
Yes.
terms of when you get down to the rules framework.
Yes. But again, I mean, if it meets the definition, well, is it simply because it's not listed as a subset under large format retail?
No,
that it's not.
No, it's to do with the fact of the specificity of the actual activity and its definition. That's what will trigger for trade suppliers as separate from another type of large format or big box type of retail.
Okay.
Your classic Bunnings or big mega Mitre 10 is both, of course.
Yes, that was my next question. I mean, if there's a trade supply like Bunnings, that's 2,000 square metres in area, is it still a trade supply outlet, or is it a large format retail activity?
No, it'll be a trade supplier. The definition, there's that, because there's a specific definition for it, it'll fall within that.
Yes. Well, it actually falls within both, but you're saying it more specifically.
More specifically, because it clearly is about that actual activity.
You happy with that?
Do you need some clarification where an activity will fall within more than one defined activity, like combination activity, about how they're treated? Because what you've just said appears to me to be logical, but I can imagine a lot of expensive lawyers dancing around on a pinhead for many days in the Environment Court arguing whether that's correct.
Yeah, and I agree. That's why when I was looking, I was thinking about there does need to be more guidance about how to use nesting tables and definitions generally, because at the moment it's silent on how you use them. I've explained it, but I agree that most plan users may not have that automatic knowledge. So I think it would be useful. And again, so we'll give some thought about the wording for that.
Thank you, Mr. Eklund. Just finally from...
Well, and just related to that, hopefully there's submissions that seek that to give scope for us to be able to include that. Within
Yes, I would. So why I'm thinking now would be something like kind of sort deletion of a number of submissions on the got a plain and common meaning. Now I've recommended that that be rejected and the definition kept, but the issue that they raise could look at that as being accepted in part, because the issue is the lack of clarity as to when a definition applies and when it doesn't apply. So that would be my immediate thinking. So I think there is that scope, but I'll just need to drill down into that a bit more.
David?
Yes, could you just help me with the table that you handed up this morning? And we can probably do it in real time. The integrated retail activity, if we added that as a fourth column, do you know offhand what the status is in the various zones?
So that one would rely on the default role. So generally speaking, in the commercial zones, the default is discretionary. In the general industrial zone, default tend to be non-compliant, but trade supplies are specifically provided for in general industrial. But otherwise, it would default to discretionary.
Even in the central city zone?
So on myself.
Well, look, to save time now, I was wondering whether you could update that table
Okay.
and present it as part of your reply so it comes in officially. And one final observation, sir, and it doesn't relate solely to your report at all, Mr. Eklund, but I'm just a little bit perplexed that some of the recommendations refer to accept in part or accepted in part, when in fact there doesn't appear to be any change being made to give effect to the relief sought by the submitter. And there are several examples. Converse to that, if you look at your report, Mr. Eklund, page 17, where there's parts of this, parts of the submission from Kangaroo are being accepted in part, but others are being rejected. That to me, that seems an example of a true accept in part, at your paragraph 113. But there are other times where I've looked at the recommendation and it says accept in part, yet there's really no change being recommended at all, and I'm just wondering why the team have accepted on that terminology when really perhaps a more accurate description of the recommendation is reject.
Just if you could find me what the example just so I can be clear about that one.
Right. Okay.
Now, I found one that was accept where I thought should have been accept in part.
Yeah. Conversely, yes, I'm sure there is. Okay. Paragraph 75.
75.
Yes.
Yeah.
Now, there's no changes resulting in relation to that submission from Forest and Bird, yet the recommendation is that their submission be accepted in part. Whereas Kaingaroa's submission is reject, and again, no changes, because there are no changes being...
That one there is to do with the setback, and the reason why I put it as accept in part is that they are wanting changes to be made, but then when I looked at the definition, it actually deals with the matters that they were concerned with. So
So-
for
so-
me, no changes were needed, but it's still, so we're accepting it in part because no changes are needed because we accept the point they've made, but it doesn't need to change. Whereas their relief sorts did seek some changes.
When we come to deliver our recommendations or decisions on the plan, we'll probably have a table at the end of our report that has a column that has a decision, which is accept, reject, or accept in part. And we'll take some guidance from the recommendations and we'll decide whether we agree or disagree with recommendations. But we're going to have to be very clear in our decision as to whether the submission has been given effect to or not. And just in that one example, and there are several that go across the reports. I would have thought that that's a reject, even though, I mean, there might be an agreement with the submitter, but that you still haven't changed the relief. You haven't given effect to the relief that they've sought. So how is that an accept in part? Other than a nicety.
Well, the relief sought was to amend that definition to provide for features and not just setback from
Okay.
boundaries.
And what alteration was made?
And no alteration is needed because the definition already does that.
Yeah, so that's a reject. You've rejected the need for an alteration because there is no need to make the alteration.
Is the difference between the two of you? You're talking about accept or reject the reasoning,
Yes.
and the Commission is talking about accept or reject the specific relief sought, and we need to be clear which it is. Like, or put another way, you're saying that you've accepted the vibe, but not the actual relief.
Yeah, I suppose that the issue there was, for that particular example, was what the submitter was seeking in terms of their intent was still met, but I take the point that the actual relief was the change, and we didn't need to make a change, so you look at that as being a reject of that particular submission point because there's no change.
Well, how does that translate into the your Part B recommendations?
So what's
You've
listed?
got the officer's recommendation column, 3 from the right, and presumably where that says accept in part or accept or reject, that would they are derived from the text within the report. Those recommendations in column 1, 2, 3, 4, 5, 6. In your table at the end of.
Yeah, so in terms of the last column identifies where any changes are made to the text. So they would need to go back to the actual text itself to look at the reason.
Okay. I don't think I can take that any further, sir.
Yes, I don't think so. Okay, thank you very much. That concludes the hearing of Stream 1. There is one step remaining, which is for the council team to present their reply. As I previously noted, we will give Mr. McDonnell some specific, I was going to say guidance, but that's putting it too high. Some questions around the mapping issue that we will ask be specifically addressed. I think the council reply is due 22nd October. We will give you that note, Mr. McDonnell, just as soon as we can put it together. And I will adjourn the hearings until the commencement of Stream 2 with a slightly reduced team of commissioners on the 29th of October. Thank you, one and all.